Thank you so much for joining for our mid-year California labor and employment update. This is the 8th webinar in our 2024 labor and employment webinar series. And we are excited to join this series to give a little bit of an update on what's been going on out in California over the last 6 months or so since we had our last webinar in this series. I am thrilled to be joined by members of our California team, my colleagues, Senior Counsel Andrea Chavez and Associate Samuel Rose. We are all in the Labor and Employment Practice Group out in California. And we are excited to join today. We will give you a little bit of variety with each of us jumping in on various topics. For those of you who have heard us speak before, you probably are familiar with our bios, so I won't spend too much time getting into the details, but we have our bio slides. In case you're interested, we all participate in both the labor and employment practice groups as well as the OSHA practice groups, and are all located out in California. So this state keeps us very busy on both practice areas, and we have quite a bit of content kind of touching on a lot of different topics today, but generally speaking, we will give you an update on what's happening out of the legislature. California has very active legislature, and we've seen some new legislation come through already that we can update you on, and then we'll give you just a heads up about what the rest of the legislative session looks like for 2024 and what you can expect coming down the pipe. And then we will go over just some key court decisions and give you some insight into what's happening on that. The courts are very active, so it's not an exhaustive list by any means, but we wanted to highlight some of the major developments that we've seen. Diving into our legislative update, the first topic we wanted to discuss is for those of you who are following PAGA, I know it's a kind of something that keeps people up late at night. PAGA is the Private Attorneys General Act in California. It's been in existence since 2004, and it lives in the labor code in California, and it allows not quite a class, but aggrieved employees to seek penalties for labor code violations. And it essentially allows an employee to put on the hat of a agency, of a California state agency, and collect penalties that state agency would otherwise be able to collect. And they can collect them on behalf of themselves and other aggrieved employees, so employees who are similar to them. And the penalty structure is split so that the state agency, the Labor Workforce Development Agency, recovers 75% of the fees, and the aggrieved employees recover 25%. And there's attorney's fees that come with that. So if a plaintiff brings a PAGA lawsuit, and there's likely to be a recovery for attorney's fees and costs, and then the penalties would be split in that fashion. So there's been efforts over the years to reform PAGA. There's quite a bit of, and just going back to the previous slide just for a moment, there's been a lot of work to try to see if there could be improvements to the legislation, because the labor code sections themselves are fairly simple, but there has been a lot of court decisions that have created this landscape for PAGA that has made it very challenging for employers. And some of the examples of that are situations where employees can have a PAGA action based on very technical violations of the labor code. And because of how PAGA is structured, where penalties are issued per employee per pay period, the penalties can get very large very quickly. So there was actually a proposition that was set to be on the ballot this fall that would have made a huge change to PAGA. And right up against the deadline for that proposition to appear on the ballot, the legislature, in combination with labor and other stakeholders, put together a legislative package that updated and changed PAGA quite significantly. So the two pieces of legislation are Assembly Bill 2288 and Senate Bill 92. They passed on June 27th, and they became effective on July 1st. The governor signed them right after the legislature passed them. And so moving on to the next slide, we just wanted to highlight some of the kind of high level changes that this PAGA reform brings. And, you know, it remains to be seen how this will play out and how, you know, plaintiffs and the judges will use this new version of the PAGA legislation. But there are some really significant changes in this legislation. So the first is regarding standing. It has been the case that an aggrieved employee, so long as they personally suffered at least one of their alleged violations, they could assert violations that they did not themselves experience, but that other members of the aggrieved employee kind of class had suffered. So this PAGA reform changes that. An aggrieved employee must personally suffer each alleged violation, and the amendments clarified that it has to be within a 1-year statute of limitations. There are some minor exceptions to this standing rule, but that's the main takeaway. There have also been some, you know, one of the pushes for PAGA reform is a more robust opportunity for employers to cure violations, particularly violations that there might be a legitimate dispute over, or they might not be aware of it. Some of the, you know, if there's a technical violation, and you know, an employer name was misspelled on a pay stub or something like that. So the changes also include changes to opportunities for cure, including an opportunity for early evaluation of a case at the beginning. For smaller employers, there's an opportunity for early evaluation kind of outside of the litigation context. And for larger employers, there's an opportunity for that at the very beginning of litigation. Moving on to the next slide. Another really, really huge change is on the penalty share. So I had mentioned that it was a 25%, 75% split. Now the employee share has increased to 35%, and the state agency share has reduced down to 65%. So one of the criticisms of PAGA is that such a large amount of the recovery goes to the lawyers in the plaintiff's lawyers in the form of the attorney's fees recovery, as well as the agencies, which do not always have the capacity to bring the sheer volume of PAGA suits that the employees' attorneys are able to bring. So this was seen as a better balance on that front. And then the penalty structure, the way that it existed before, is that there's $100 penalty for the initial violation. And again, like I mentioned, that's per violation, per employee, per pay period. But then there's a heightened penalty of $200. And so this PAGA reform clarified that $200 penalty is reserved for employer conduct that is malicious, fraudulent, or oppressive, and specifically where in the last 5 years, either the LWDA or a court has determined that an employer policy or practice giving rise to the violation was unlawful. So there has to be a point in time where the employer was on notice affirmatively that they had a previous violation for that heightened penalty to be applicable. Another really, really huge part of this change is both on the availability of penalty reductions and the availability of penalty caps. So some penalty reductions exist where there's a cap on the penalty. So rather than $100 per violation per employee per pay period, there are certain categories where they're $50 and $25 and certain circumstances where they're even lower than that. And just to give you some examples, one of the penalty reductions is for the wage statement requirements. The labor code provides that very specific information must be provided on the wage statements. And if that information is not available, that's a technical violation. Even if the information that the wage statement is supposed to provide to employees is really still available to the employees. So this specifies that if an employee can still promptly and easily determine from the statement the information that they're supposed to be able to gather from it, then there's an availability to reduce that penalty to $25. There's a similar penalty reduction where an employee is not confused or misled about the correct employer entity, and that's a reference to the requirement that the employer entity's full name be visible on the wage statement itself. And then there's another one for isolated non-recurring events that don't exceed 30 days or 4 pay periods. And that recognizes that there might be a error in a payroll system or some glitch that gets fixed very quickly, and that is treated differently than some other violations. There's also an allowance for penalty caps, and some of them work with a 15% cap, so that would be a $15 penalty. Where there is notice provided, PAGA cases require notice. The employee give notice to the LWDA and the employee. So there's an opportunity where corrective action is taken after such notice for a penalty cap. And then there's an additional availability for a 30% penalty cap. So that would be a $30 penalty, where there's correction and cure after the notice period. There's also a limit on the ability to stack penalties. So when we evaluate a PAGA case, we often see, a number of violations that stem from a single violation, right? So if there's an issue on the wage statement, then maybe employees weren't paid on time, or they weren't paid appropriately at the end of their employment. And there's some other derivative claims that can stack up penalties. So you would get 100 for this violation, 100 for this violation, 100 for that violation. This puts a limit on some of that penalty stacking ability. And the last one I want to mention on this slide is there's an adjustment for employers who pay on a weekly basis. Again, because the penalties are tied to the pay periods, if an employer is required to or happens to pay on a weekly basis rather than every other week or twice a month, then their penalties are inherently bigger, almost double. So in recognition of that, there is a 50% reduction allowed for employers who pay on a weekly basis. The PAGA reform is something that's really important for PAGA cases going forward. And so if you do have questions about that, or there's information that you gather about how this is working, kind of practically speaking, that's something that we're certainly happy and interested to talk to you about to see how this changes the landscape. But for now, I will pass it over to my colleague Samuel, who will talk about SB 478.
Thanks, Lincoln. So SB 478 is California's price transparency bill. There's been a lot of focus over the last couple months, even into last year, on junk fees and fees that are tacked onto the price or on sale of goods. The Biden administration had made targeting junk fees when it comes to concert tickets priority. They have been targeting fees on credit cards. And SB 478 is California's manifestation of this current topic. The bill was introduced by Bill Dodd in the legislature, and basically it applies to the sale or lease of most goods and services for a personal use, including concert tickets, hotels, lodging, restaurants, food, and food delivery. Um, it basically requires that any price advertised by an employer include any additional fees that are being tacked onto that price, excluding taxes or fees imposed by government and shipping fees. And so this was something that got passed very quickly and also came with an urgency clause. And so it took effect July 1st, rather than waiting until January 1st. SB 1524 is related to the price transparency bill. And essentially what happened is that after the bill was passed, the California Attorney General had issued a memo that said that restaurants were going to be subject to SB 478. And so they would have to include any additional fees in the advertised menu prices of food or drinks that are on their menus. It appears that that's not what Bill Dodd intended by it, because he then co-sponsored SB 1524, which was an exception for restaurants to the price transparency bill. And it basically took restaurants out of the requirements of most of SB 478. That bill passed on June 29th, basically a couple days before SB 478 went into effect. And it also went into effect immediately. So restaurants are now only required to disclose on menus that a mandatory fee is assessed on the bill, and then explain what that mandatory fee does. And so oftentimes you'll see on menus, we're charging an 8% fee so that we can provide our employees with healthcare or higher wages, or we don't tip at this establishment. And so that message is going to be required to be on menus going forward, but it's not going to have to be included in the price of the actual menu items.
All right, thanks, Sam. So to start, there are a few minimum wage updates that I wanted to touch on. Some are industry specific and some are location specific. So just as an initial reminder, as of January 1st of this year, the statewide minimum wage increased from $15.50 to $16 an hour, and the exempt employee salary threshold increased from 64,480 to 66,560 per year. There was also increases to specific industries. For example, as of April 1st, 2024, a fast food restaurant that is part of a national fast food chain has to increase its minimum wage to $20 an hour. And then to be considered a national chain, the company must have at least 60 establishments nationwide. Okay, so over 40 cities and counties have increased their local minimum wage with an effective date of July 1st, 2024. And here are just some examples of some of those local ordinance, but just make sure that you check your local ordinance to see if you're compliant. Okay, so if you're in the healthcare sector, you may know that there's been quite a few statutes passed recently about the healthcare minimum wage, and it's really been kind of messy. So lawmakers passed AB 525, which would have raised the minimum wage on June 1st, generally to $21 per hour, and as high as $23 per hour for some specific employees. But then, due to budget reasons, California passed AB 828, which pushed the effective date of AB 525 back to July 1, 2024. Then, AB 159 was passed, which further delayed the effective date and established these new potential triggers, which establishes 3 potential effective dates for this law to go into effect. And I listed them here, and you'll see they're pretty complicated, which is all to say, if you are in the healthcare sector, just keep on top of this law, since determining what your minimum wage now is going to be a little more complicated than usual. Okay, SB 553. I know we've talked about this a lot in our prior webinars, so if you want an in-depth presentation on it, please go revisit those. And because of that, I'm not really going to go into it too much here, but it just as a reminder, July 1st of this year, most employers had to establish, implement, and maintain an effective workplace violence prevention program. As you see here, there are some exceptions, including teleworkers and workplaces with less than 10 employees present at once that are where the workplace is not open to the public, as long as those workplaces do have an IIPP. So just a quick review, under SB 553, you're required to maintain a plan, conduct hazard assessments, implement abatement measures, maintain a violent incident log, conduct investigations into workplace violence incidents, provide training, and keep records according to the record keeping requirements. So if you have not rolled out your program, or if you have any questions about your program and you feel like you need some help, please feel free to reach out to us. I know everyone on this panel has done quite a few of these programs. Okay, so the last thing I'm going to talk about is SB 2011, and it just passed a few days ago, and it'll have an effective date of January 1st, 2024. So the existing law requires the Civil Rights Department to establish a small employer family leave mediation program. And under that program, mediation had to be initiated when there was a request from either party in a matter alleging family care or medical leave or bereavement leave violations. And then to be subject to this law, employers had to have 5 or between 5 and 19 employees. So this new law, sorry, the current law was supposed to be temporary, but SB 2011 makes it permanent and adds reproductive leave violations to the program.
Thanks, Andrea. So we just want to touch a few other bills that have recently passed in the legislature, most of which will not take effect until January 1st, 2025. The first one is AB 1870. Obviously, California law already required employers to post a variety of information related to an employee's rights under workers' compensation law. AB 1870 is going to add the fact that an employee is entitled to consult an attorney related to any workers' compensation injury or case. And so effective January 1st, 2025, you'll just want to make sure that your workers' compensation postings are up to date and include that right for employees. Another posting law is AB 2299. The law already requires that employers post employee rights and responsibilities under whistleblower laws. AB 2299 requires the labor commissioner to develop a model posting, which would be deemed to comply with these posting requirements. And so employers will be able to just use this model posting in their workplaces and not worry about being out of compliance or the agency's, scrutinizing the language that's in every posting. And this will become effective January 1st, 2025 as well. And we'll be keeping an eye out for the labor commissioner's model posting. The last legislative update we want to provide is AB 2751. This has not been passed or signed. It's currently making its way through the legislature, but it's a very interesting law that we wanted to bring everyone's attention to. It would require employers to establish a workplace policy that gives employees the right to disconnect from communications from the employer during non-working hours. And so the law basically provides that the employee and the employer would have to have an agreed upon time where they are not, what their non-working hours are. So if their working hours are from 9 to 5, there would have to be a policy in effect that from 6 p.m. to 8:59 a.m., the employer is not permitted to contact the employee in any way. Obviously, this law has not been passed, so there's a lot of ambiguities. There are exceptions for emergencies and scheduling. The law doesn't define what an emergency is, and it doesn't define what type of scheduling issues are permissible. And so there will either have to be some sort of clarification during the process of drafting the law, or obviously there will be litigation if the law were to pass. It also doesn't specify whether the workplace policy needs to be in writing or if it just needs to be a policy that the employers maintain. So just an interesting law that, you know, puts another obligation on employers in California and makes running a business in the state somewhat complicated. So we just want to flag that for everyone as it makes its way through the legislature.
Thanks, Sam. So that's the perfect segue because, you know, we only highlighted one piece of legislation that's pending in the legislature, and that's because we're kind of in this period of the calendar year where we don't know if bills are going to survive or if they're going to pass and get signed. And then we don't know if the governor is going to sign all of them. So the folks who are working in the legislature and those who work in this space are very, very busy right now. And we're in a little bit of a limbo land right now where we don't know exactly what's going to happen. So it's possible that we have a whole flurry of new legislation in the next couple of months. The September 30th, 2024 is the last day for Governor Newsom to sign or veto any bills that do get passed by the legislature. So for those of you who were able to join last year, we had our inaugural summit that covered both labor and employment and OSHA. So we are again trying to schedule that very soon after the end of the legislative year, so that we can bring you a timely update on anything that does pass, that is signed by the governor, if anything has urgency legislation where it would take effect immediately or otherwise, so that you can prepare for anything that takes effect January 1st, 2025. So if anybody is interested in more information about this year's summit, feel free to reach out to any of us. But have no fear, we will have more updates for you down the line, and you will know whether or not that communication with employees during non-working hours made it through or not.
Thanks, Megan. So now we'll move on to important court decisions that have been issued during this year so far. We want to start with a general arbitration takeaways. Obviously, arbitration is an extremely volatile and ever-moving area of the law in California, and there are dozens and dozens of cases that are released every year about arbitration clauses and arbitration process. And so we tried to sort of take those cases and distill it down to two main points. The first is that employers have to ensure that they pay their fees within the window provided by Civil Procedure Code 1281.97. The Court of Appeal has released dozens of opinions since 1281.97 was enacted in 2019, upholding this pay or waive arbitration statute. And that includes two cases this year: Suarez v. Superior Court of San Diego County, which is out of the 4th Appellate District and was issued in January, and Keaton v. Tesla Inc., which was out of the 1st Appellate District and issued in June 2024. In both of these cases, the employer failed to pay their arbitration fees within the 30-day window, and the court granted plaintiff's motion to waive arbitration. So, constant reminder from the California courts: make sure as an employer that you pay those fees, because they love holding employers accountable for that window and removing the case from arbitration if they can. In a rare win for employers, there was the case of Hernandez v. Sonnen Enterprises. That's out of the 2nd Appellate District, and it was issued in May of this year. The court found actually that the Federal Arbitration Act preempted Section 1281.97, It's a huge win for employers because it basically means that the arbitration would proceed under the Federal Arbitration Act, which is much more employer friendly than under the California arbitration law, which is more employee friendly. I want to caution employers to get too excited because there are plenty of cases, as I mentioned, where they do apply 1281.97, and there are plenty of cases where they say that the Federal Arbitration Act does not preempt California law. So it's a cautionary warning, but given this case, it's very important that employers ensure that their arbitration agreements expressly state that the arbitration is governed by the Federal Arbitration Act, substantively and procedurally, and to in the future try and make the argument that the California law is preempted. So those are two takeaways related to arbitration. The other case that was released is Ortiz v. Randstad in-house services. In this case, the Ninth Circuit held that California warehouse employees belong to a class of workers engaged in foreign or interstate commerce, and they're therefore exempted from the FAA. So the FAA exempts transportation workers or workers who are engaged in interstate commerce from its requirements. This case essentially broadens that definition to include workers in the warehouse, not just transportation workers who drive trucks or are involved in the actual transportation of goods. And then in Bissonnette versus LePage Bakeries, the US Supreme Court issued an opinion that a transportation worker need not work in the transportation industry to be exempt under the FAA. So this is both these cases, the Ninth Circuit and the US Supreme Court take a much broader view of the transportation exception to the FAA. And so you just want to be aware of that when you're drafting your arbitration agreements. The next case we wanted to cover is Applied Medical Distribution Corp versus Durrells. This was a trade secret case. As many of you may know, in trade secrets, the plaintiff can recover damages and also a huge amount of attorney's fees. And in this case, the jury had found that the employee had misappropriated employer's trade secrets, but found that there were no damages or unjust enrichment that occurred. And then the jury found in favor of the employee on all other causes of action. There was a number of issues that went up on appeal, but the most interesting one is a matter of first impression. The courts had never considered this before. And the Court of Appeal held that a plaintiff in a trade secret misappropriation case can recover, as part of their damages, expert fees incurred to stop or mitigate misappropriation. So if you, as part of your trade secret case, have to hire an expert to either, a forensic expert to look at electronically stored information, or have an IT person try and access a computer to prevent the employee's misappropriation, those costs for that type of expert are going to be recoverable as damages rather than just as a fee that's part of the cost of litigation. The next case is Jones v. Riot Hospitality Group. This is a spoliation case. The facts are interesting, so I just want to go through them fairly quickly. I'll note that this is a Ninth Circuit case, so it is binding on California, but the trial court was the district court in Arizona, and so we don't know whether a California district court would engage in this same type of procedure during the course of litigation, but we just want to highlight this as a Ninth Circuit case. In this case, the plaintiff was a waitress at a bar in Scottsdale, Arizona. The plaintiff had sued her employer for discrimination. During the litigation, the plaintiff was ordered to produce text messages with some of her coworkers. And after failing to do so, the district court ordered a third-party expert to search plaintiff and the coworkers' phones to try and access those messages. The third-party expert did so, accessed the messages, and sent them to the plaintiff's lawyer, who then went on to not produce the messages to opposing counsel. The district court then ordered the specialist, the third-party expert, to send the messages directly to the employer's counsel, and I think fined the plaintiff somewhere around $65,000. Once the employer's counsel received the messages, they realized that many of them were missing. they had the third-party expert look at the ones that they were provided, and the third-party expert had determined that there was nowhere near the number of messages that she had pulled from the phone. And the employer then filed a expert report with the court saying that there was an orchestrated effort to delete and or hide evidence subject to the court's order, and the district court dismissed the case. The Ninth Circuit affirmed the dismissal, and so this is a case, one of the rare cases where the Ninth Circuit sides with employers. Always make sure that you're looking at your discovery, ensure that you're receiving everything from plaintiff's counsel, and if something looks off or it doesn't seem like you've received the amount of information that you should have, you definitely want to pry into that and find out if there's something nefarious going on. With that, I will turn it over to Andrea to discuss some more case law.
And so the next case we're going to discuss is Kuigoa, sorry if I mispronounced that, v. Department of Veteran Affairs. So this case, essentially, the plaintiff filed a complaint with an anti-discrimination agency and a court, and the two complaints told different stories. He essentially asserted facts in the civil suit that were not identified in the agency complaint. And based on that, the employer moved for summary judgment, alleging that the plaintiff did not exhaust his administrative remedies with the anti-discrimination agency. The trial court granted his summary judgment, and the Court of Appeals affirmed it, noting that by withholding the facts from the agency, the plaintiff deprived that agency of the ability to investigate the supposed wrongs that were the focus of the civil suit. So this is just a reminder to review your agency complaints and see if there's anything in there that is not in the civil complaints, and then take action if you find that there's discrepancies. Okay, Lusardi Constructions v. DIR. So here a school district awarded Lusardi, who was the contractor, a contract for a construction project, and then Lusardi contracted with a subcontractor to assist with that project. This subcontractor failed to hire apprentices for the construction project, which was apparently required. There was required to be a certain apprentice to journey person ratio. And the Court of Appeals found that both the contractor and subcontractor are jointly and severally liable for penalties under Labor Code 1743. And that's even though the subcontractor was the one that failed to hire the apprentices. And then Labor Code section 1743 states that the subcontractor and contractor shall be jointly and severally liable for all amounts due pursuant to a final order under this chapter, meaning the chapter of Public Works, or agreement thereon. So this just another reminder that if you are a contractor, you could be held liable for the acts of your subcontractor. And Huerta v. CSI Electrical Contractors. So here the facts are important, so I'm going to go over them real quick. So when employees were arriving to work, they had their vehicles checked. The security checks included the scanning of the employee's badge and an intense or thorough inspection of the car. And because the employees had to wait in line and go through this inspection, this whole process could allegedly take up to 30 minutes. Then after the security check, employees allegedly had to drive another 15 minutes to get to the employer's work parking lot. So during this entire time, employees were also required to comply with certain company rules, like going the speed limit, no drinking and driving, the harassment policy. And so the court asked two important questions. Was the time spent going through the security checkpoint compensable? And was the time spent driving from the security checkpoint to the parking lot compensable? The court found that an employee's time spent on an employer's premises awaiting and undergoing an employer mandated security procedure, such as the one here, is compensable as hours worked. And that's really because of the, it's fact specific and because the high level of control in this case. Because the court also noted that simply requiring employers to scan a badge to enter or exit a parking lot is not sufficient control to require compensation. And then to the other question, the court found that the time driving from the security gate to the parking lot was not compensable. And, just based on the fact that the employees were subject to company rules during that drive, just being subject to those rules didn't have the level of control that was required to make it compensable. And if the opposite rule or the opposite finding was true, then, like time spent looking for a spot, walking to the door, taking the elevator, that would all essentially be considered compensable. And the court said like such a finding would be way too broad and unworkable for employers. But even though the court found that the drive time was not compensable as hours worked, the time might be paid as employer mandated travel time under wage order 16 if the security gate was the first location where the employee's presence was required for an employment related reason other than the practicality necessary of accessing the work site. And the court didn't make a finding on the specific facts here. But it's always important to know what's in your wage orders. This specific wage order only applies to construction, drilling, lodging, and mining industries. But yeah, it's kind of an unusual one. So it's always important to, again, review the wage order that's applicable to your company. Yeah, so basically the takeaway is if you require employees to submit to security checks or anything else that is similarly like burdensome or controlling prior to clocking in, just be careful and make sure that the employees are paid for that time. Okay, so next, Naranjo v. Spectrum Security. This case has really been around for a while. In the prior proceedings, the court found that the company did owe wages for unpaid meal and rest premiums. And then the question here is whether the company was required to pay penalties under Labor Code Section 226. And then Labor Code Section 226 requires employees to issue accurate wage statements to employees that include a bunch of information, including gross and net wages earned. And knowingly and intentionally failing to provide accurate wage statements can lead to penalties. So here the company potentially faced, again, penalties under 226 because its wage statements did not record the unpaid meal and rest break premiums, which are now considered wages under the law. However, at the time the wage statements were issued, the law was unclear as to whether such premiums were considered wages. A prior decision actually in this matter is the decision that established that such premiums are wages. So here in this decision, the Supreme Court found that an employee's objectionably reasonable good faith belief that it has provided employees with accurate wage statements precludes an award of penalties under 226. But that courts must conduct a fact-specific inquiry into whether the employer reasonably and in good faith, although mistakenly, believed it complied with the law. So essentially a good faith belief, a good faith defense is based on a misunderstanding of the law and is only available when there is a genuine uncertainty regarding the employer's obligation. So if the law is well established, you won't have this defense.
Thanks, Andrea. So just a few more cases, and then I see we have at least one question in the chat that we'll get to, and we'll wrap things up for today. But we just wanted to remind folks, if you didn't see this, I believe we wrote about this on our employer defense blog, but there was a PAGA case that came out in January from the California Supreme Court that resolved a split amongst the Court of Appeals in California. And the California Supreme Court found that the trial court lacked authority to dismiss a PAGA claim based on manageability grounds. So PAGA cases are, as I mentioned, not class actions. And in the class action context, those cases have to be manageable in order to go forward. And so there was a period of time where courts were considering whether PAGA cases could be dismissed because they're not manageable. They don't meet those requirements. But the California Supreme Court said, no, PAGA cases are not subject to the requirements of class actions. And so that has been decided at the Supreme Court level for California. So that question is resolved for the time being, unless there's further changes to the PAGA legislation itself, or the PAGA statute itself. The next case we wanted to highlight is Starbucks Corp versus McKinney. And this is we're going to kind of conclude our discussion of cases today in areas of unfair labor practices and the National Labor Relations Board. And so this case, we had Starbucks employees invited news crews to visit the store after hours to promote a unionization effort. And multiple employees were fired who were involved in the media event. The NLRB filed a petition. Well, they filed a complaint first, and then they filed a petition seeking to enjoin during the administrative proceeding a preliminary injunction so that those employees would have reinstatement of their job while the administrative proceeding was working its way through the litigation. So this case is really about kind of the standard that you apply in order to decide whether there's been an unfair labor practice. Courts applied a two-factor test, and the U.S. Supreme Court held that in deciding whether to grant the NLRB's request for preliminary injunction, they actually needed to apply this four-part factors from this case, Winter versus the NRDC. So they have to look at whether they're likely to succeed on the merits, whether they're likely to suffer irreparable harm in the absence of relief, whether the injunction is in the interest of the public, and then balancing equities in favor of injunctive relief. So they vacated the decision and remanded it back to the lower court to apply the standard that they determined was the appropriate one. The reason I kind of get into the weeds on that sort of what the standard applies is, I'll come back to that in one of the cases that I'm going to mention on the next slide. Okay, so we have four more cases that we just wanted to highlight. The first is Home Depot, USA, and Antonio Morales. So this is an NLRB decision that came down earlier this year, and it's an interesting set of facts because there was a determination that the employer violated federal law in directing a particular employee to remove. They had handwritten BLM on their apron, and the employer had asked them to remove that from their apron because it was out of compliance with company dress code. Now, under the facts of this particular case, they found that wearing that acronym on their uniform was protected concerted activity under the National Labor Relations Act. And the important context for this case is that that particular employee and his coworkers had already engaged in several instances of protected concerted activity protesting racial discrimination in the workplace. So it was kind of part of a larger effort and a bigger context, but it does kind of raise the issue of the necessity to really think through actions that employers take, and whether there's any argument that there could be a concern that it could be seen as protected concerted activity, what the employees are engaging in, so that you're not inadvertently, stepping into a potential claim, and just giving some thought into whether your policies and practices could give rise to a claim. I'll take this a little bit out of order because the reference to Stericycle on the bottom is kind of a similar issue where the board clarified the standard to apply in deciding whether a policy is a violation or not, and that particularly has us kind of thinking in terms of policies and procedures that come up in handbooks, whether you want to review the language and make sure that it's in compliance with the standard, and make sure that you're not inadvertently restricting employees' ability to engage in protected activity. And this Home Depot case gives an example of how that might play out with, a company dress code that might on its face look fine, but in practice could have some landmines for employers. The Valley Hospital Medical Center case I wanted to mention comes out of the Ninth Circuit because the judge was very critical of what we often see in NLRB cases, where there's a bit of a pendulum, where there's a back and forth in what the decision is, and it leaves employers and other interested parties kind of in a state of limbo. So in that case, the particular context was whether at the expiration of a collective bargaining agreement, whether an employer can continue to or has the obligation to continue to take paycheck deductions for union dues and then transmit those union dues directly to the union. So this was a situation where there was 40-year precedent on one side of the issue, and then a little bit of back and forth and back and forth. And here the panel said, no, employers can't just stop doing that deduction and remitting the union dues to the union when the collective bargaining agreement expires and folks are in negotiations. But he issued an entirely separate concurring opinion that was incredibly critical of this kind of back and forth nature of the decisions. For the last NLRB related case, I'm going to pass it back over to Sam, but while he's turning on his camera, I just wanted to highlight that we are so excited to have a new partner at Con Maciel Carey, Letitia Sillis, who has extensive experience in this space, in labor particularly. She worked for the NLRB. She recently worked as the Executive Director of Labor Relations for the University of California statewide. So I encourage you, if you have any questions about these cases or any labor issues, reach out and we can put you in touch with Letitia, who will also be joining us in October for our summit. Thanks, Sam.
Thanks, Brandon. So real quick, we just wanted to talk about this Space Exploration Technologies Corp versus NLRB. It's a hot off the press case. As you can see, it was issued July 23rd, 2024, so only 2 days ago. This is a really interesting case. It's not on the merits yet. This case involved a preliminary injunction. A SpaceX employee had sued SpaceX for, I believe it was discrimination. And it went to the NLRB, and SpaceX is essentially challenging the NLRB's ability to adjudicate cases through administrative law judges and through the members of the National Labor Relations Board. The argument is that they the use of ALJs and the members to decide these cases are the people are unconstitutionally insulated from removal. And what they're relying on is the recently issued case from the Supreme Court in Jarkissi, which was limited to the SEC's ability to use administrative law judges to proceed on fraud cases. They are now trying to use that case to argue that administrative law judges in the NLRB and in the discrimination employment context are also unconstitutional. And so Jarkissi was issued in June. We are now in July, and we are already seeing parties try and use that case to attack other administrative agencies and their ability to enforce the statutes that they do enforce through the administrative process. And so in this case, the Texas District Court had found that in a petition for preliminary injunction that SpaceX is likely to succeed on the merits. It doesn't rule that they did or that they will, but that it's likely, and that's the standard that they have to meet in order to get a preliminary injunction. And so at this point, at least in this case, the NLRB is enjoined, they're prevented from proceeding administratively against SpaceX on this discrimination claim. And so it'll be interesting to follow this case and see where it goes. I would guess that it will make its way to the Court of Appeals, and we'll see if it ends up going to the Supreme Court and what they rule on that. But just a hot off the press case impacting employment based on a recently just issued Supreme Court case. And so we just wanted to bring that to your guys' attention.
Thanks, Sam. Okay, so we got one question about Assembly Bill 2751 and whether it impacts salaried employees. So this is really interesting because while there's an exception built in, and this is in the works, so this is still in the legislature, there could be amendments at any moment, and it hasn't been passed and it's not signed by the governor. But that said, it only has an exception for employees who are covered by a valid collective bargaining of, hourly employees are paid based on the hours that they work, and exempt employees are not. They're paid based on the job that they do, and it's not necessarily tied to each and every minute that they work. So it's not clear in the language itself that there's any exception for exempt employees. Now, one can think, well, maybe that's intentional, that it's a right to unplug piece of legislation, and that's the whole point. But it raises a whole slew of questions about practicality. And at least my initial thoughts on this, it really kind of blurs that line on what it means to be an exempt employee. So we'll see if there are any changes to that, or if it dies in the legislature or makes it through. I'm just checking to see if we have any other questions. I think with that, I will just go over. I know we're at the top of the hour again, so I want to be respectful of everybody's time. This is the rest of our 2024 employment webinar series. For those interested, we would love to see you in person in October if you're able to join for our summit. We also include some slides on our blogs. We try to keep the employer defense report updated with really critical updates. So that's a good resource for those who are interested in subscribing, so you get the updates right away. And thank you so much for joining us. This is the information Andrea mentioned, how we can assist with compliance with the workplace violence prevention requirements. And this is our contact information. Again, just as a follow-up, you will receive, if you registered for the webinar, you'll receive notice when the webinar recording and slides are available. Thank you so much for joining us today. We really appreciate your time, and it's been a pleasure. Thanks for joining.